Test, test.
I was getting sick, and I was like, I guess I'll go represent the team. I live down the street. It's nice to leave the house. You doing that awesome thing?
lights on anyway. Well, different language schools. It goes all the way to
Good morning. Good morning. Good morning. I'm Eric Blank, and this is the Commissioners' Weekly Meeting for Wednesday, June 5th. Plant. Good to see you, and hope you're feeling better. Any preliminary comments? Are you ready to approve the consent agenda?
Good morning. Yes, feeling much better, and I am ready to approve the consent agenda.
Commissioner Goldman.
Good morning. I would also vote to approve the consent agenda.
As would I. Sitting number 23A-0078, the Purple Points Tour Company. Mr. Foreman.
Good morning, Commissioners. Wyatt Foreman of your Commission Council. This proceeding is an application for a Certificate of Public Convenience and Necessity, or CPCN, filed by Purple Mountain Tour Company, LLC. On January 19th, 2024, ALJ Merbaba issued a recommended decision granting the CPCN. On January 19th, ALJ Merbaba issued a recommended decision granting the CPCN. On April 29th, 2024, the Commission denied the exceptions to the recommended decision filed by intervener Green Jeep Tours, LLC. Before you today is a decision whether to grant or deny the motion for extension of time to file an application for rehearing, re-argument, or reconsideration, or RRR, filed by Green Jeep on May 20th, 2024. The motion was filed on the date of the RRR deadline and is therefore considered timely. Green Jeep asked the Commission to extend the RRR deadline to June 10th, 2024, and as grounds, states that its council was out of town for much of the month of May, and it therefore did not have adequate time or opportunity to consult with its council prior to the expiration of the RRR deadline. Purple Mountain filed a response in opposition to the motion, in which it argued that Green Jeep's conferral on the motion was inadequate, that Green Jeep's support for its motion was insufficient, and that an extension of time would be futile and would only serve to prolong the proceeding. I can pause here for a discussion or proceed to a recommendation.
No, I think we'd welcome the recommendation.
We recommend granting the motion nunc pro tunc to May 20th, 2024, the final day of the RRR deadline, and extending the RRR deadline to June 10th, 2024. Considering both parties' positions, Council thinks good cause exists to extend the deadline. Giving Green Jeep time to consult with its council is appropriate in this circumstance and accords with considerations of due process. Additionally, Purple Mountain will not be unduly prejudiced because it has already been granted a CPCN and can operate while this proceeding is ongoing. Council notes that Green Jeep filed its RRR application on Monday, June 3rd. So if the Commission grants the motion before it today, we will bring this proceeding back next week for a brief deliberation to discuss how the Commission will address the RRR application itself. I'll pause here for your vote on whether to grant the motion for extension of time to file RRR nunc pro tunc to May 20th, 2024.
I don't know about granting extensions because attorneys are busy, but Commissioner Plant?
I agree with the recommendation.
Commissioner Gilman?
I also agree with your recommendation.
As do I, but somewhat grumpily.
Understood. Thank you.
Proceeding number 24AL-0206PR, Ramlick, Pagosa Cap.
Yes, good morning. I'm Gary Gramlich, Transportation Staff. This is a filing by Pagosa Cab in Archuleta County, a vice letter and a tariff submitted on May 7th. The effective date is June the 8th. Under Pagosa Cab's certificate, it can provide shuttle and taxi service in Archuleta County from and in La Plata County between Durango and Pagosa, and it also goes to South Fork. It is increasing the taxi first mile rate by $1.90 and each additional mile by 90 cents. The shuttle service it provides is between Pagosa and Durango, Pagosa and South Fork, Durango and South Fork, and Pagosa and Wolf Creek. But I did provide the statistics in the info sheet for 22 and 23, which shows a very small carrier, only did 1,200 total trips in 22 and about 1,500 in 23. The revenue is also quite low because he doesn't do that many trips. The only one vehicle is operated, and the owner is the only driver for this company. There is another carrier, Wilderness Journeys Pagosa Inc. in Pagosa, which also provides shuttle and taxi service. And it's a much larger carrier, has 10 vehicles, and its revenue that does do Medicaid transportation was almost $700,000 in 23. So under those circumstances, I have a recommendation unless there's any issues.
We'd welcome your recommendation.
Would be to allow the proposed changes to become effective by operational law on the date of June 8th of this year.
Commissioner Plant.
I agree with the recommendation.
Gentlemen,
I also agree.
as do I. Thank you, Mr. Gramlich. And before we go to the next one, Mr. Foreman, if you're there, the prior case can be an ABC decision.
Okay,
Mr.
understood.
Gramlich,
Thank you.
did it. 24A-0227CP-ETA, Vale Stables. Back to you, Mr. Gramlich.
Yes, this is an application that's filed by Outlaw Ranch LLC, DBA Vale Stables. They're located in Vale. It was submitted on May 22nd. It's for an emergency temporary authority. A permanent application has also been filed. The authority requested is shuttle service between Vale Stables, which is located north of I-70. It's not in the Vale city limits, I don't believe. And all hotels located within a 3-mile radius of its address, and also the Vale Transportation Center. Rule 6204 requires that an emergency temporary authority has to include a statement of facts, establish a basis in need of the emergency for the proposed service, and support letters also should show that need. And if granted, the length can only be 30 days, but as stated, they've already filed a permanent application too. The owner of the company in her statement says, yes, they've been providing this service for 23 years. Many tourists come to Vale, may not have vehicles, and taxis aren't always available. They're open 7 days a week this year from May 24th through October 15th. Does say they will pick up passengers at the hotels and the locations and transport them to the stables. And one of the main activities there are, and I checked this on the website, are goat yoga and horseback riding. And the goat yoga seems to be very popular, whatever it is. And I didn't check any details on that, but and
should we get some supplemental?
I don't know.
To get into that?
I saw a couple of photos. It did look unusual, though, but for the goats anyway. But a support letter was also submitted on May 31st by a hotel in Vale, which states that they could use passengers need this transportation. It would be in addition to their service. Vale Stables has recently acquired a van, and please consider approving the proposed shuttle. The second support letter was submitted by the manager of the Welcome Center in Vale, and in it she discusses the Town of Vale Climate Action Plan as one of the reasons for support, as this is not, as it's on the other side of I-70, it's not readily available and could limit vehicle use. And also states there's not always taxis and rideshare options available. So as stated, there's a permanent, besides the ETA, does support for the service, I have a recommendation.
We'd welcome it.
That would be to grant the emergency temporary authority for the allowed period of 30 days.
Commissioner Plant,
I agree with the recommendation.
Commissioner Gilman,
I also agree.
as do I, and that can be an agency decision granting the temporary authority for 30 days. Thank you. 21A-0141 E. Mr. Eaton, Ms. McLaughlin.
Good morning. It's going to be a tough act to follow, but
No go yoga?
no go yoga. Good morning. I'm Michael Eaton with your advisory staff. This matter involves the proposed stakeholder PIM that Public Service Company of Colorado filed on April 30th, 2024. As you know, the stakeholder PIM filing was contemplated by the Phase 1 settlement agreement and the Commission's Phase 1 decision back in 2022. The settlement agreement and Phase 1 decision further contemplate that after the company files its stakeholder PIM proposal, interveners would have a 30-day comment period followed by, if necessary, a limited evidentiary hearing. After reviewing the company's stakeholder PIM proposal, the Commission issued decision number C24-0337 on May 17th. In that decision, you directed Public Service to make a supplemental filing that includes, among other things, detailed information regarding the actual and projected capital expenses associated with the Pueblo Unit 3 coal-fired power plant. The Commission ordered Public Service to submit this supplemental filing by May 29th. Given this supplemental filing, you also extended to June 7, 2024, the deadline for interveners to respond to the company's stakeholder PIM proposal. The Commission further required that any such responses be submitted as written testimony to help ensure clarity of record. And this finally brings us to the application for rehearing, re-argument, or reconsideration, which I'll call the RRR, that trial staff of the Commission filed on May 28 regarding decision number C24-0337. This RRR is what you'll be voting on this morning. In its RRR, staff first asks that the Commission permit interveners to file comments in response to the stakeholder PIM instead of testimony. Staff notes that the stakeholder PIM process established in Phase 1 contemplates comments instead of testimony, and staff argues that by requesting testimony, the Commission risks inadvertently signaling it has reopened the record. Staff further asserts that requiring testimony prevents parties from working together to provide the Commission with joint comments. In the RRR, staff also requests that the Commission extend the deadline for interveners to respond to the company's stakeholder PIM from June 7th to June 24. Staff argues that this extension will allow interveners to discuss the company's supplemental filing and consider joint comments. And finally, staff states that the Colorado Energy Office, the Utility Consumer Advocate, and Western Resource Advocates support staff's RRR. So there's two decisions in staff's RRR. The first is whether the Commission should permit interveners to submit comments instead of written testimony in response to the company's stakeholder PIM. And the second is whether to extend the deadline for responses to June 24th, 2024. I'll pause here for your deliberation unless you have any questions or would like a recommendation.
So I guess I'll go first on this one. I personally would not forbid staff and other parties from filing comments if that's what they want to do. We solicit written comments from the public all the time, and I read those comments and often rely on them as evidence in the record that can support our decision. Having said that, however, I'd point out in our order that sworn testimony may often be more compelling and accorded greater weight as it's subject to cross-examination and commissioner questioning in ways that written comments are not. So I'd suggest an order allowing staff and others to file written comments if they want to, but I'd also gently point out the potential benefits of sworn testimony. I'd also grant the extension of time. So with that, Commissioner Plant, your thoughts?
Thank you, Mr. Chairman. So, if I understand, extend the time frame and then allow for written testimony, but not require it, and give the parties the option of either submitting written testimony or uh, uh, comments. Is that correct?
Correct, with some language in the order, pointing out the benefits of sworn testimony.
Okay, and they would just designate what if they're submitting testimony or comments at the outset.
Correct.
Okay, yeah, that sounds good to me.
Commissioner Gilman?
Yeah, I think that's a reasonable path forward. So I agree with your suggestions, Chairman.
And I think that can be an ABC order extending the deadline and drafting an order accordingly. Does that give you what you need, Mr. Eaton?
Yes, it does. Thank you.
You. Proceeding number 22F-0263EG, Olson's Greenhouse. Mr. Gomez, Mr. DeCenzo.
Good morning, Commissioners. Mitchell DeCenzo of your Commission Council. This matter comes before the Commission to address exceptions to recommended decision R24-0144, filed by Olson's Greenhouses LLC on April 24th, 2024. Public Service Company of Colorado filed a response to Olson's exceptions on May 13th, 2024. For context, Olson's operates 2 greenhouses and uses large quantities of gas to keep its plants warm in the winter and shoulder seasons. Olson's has a service agreement with Public Service that provides for interruptible gas transportation service to its facilities. The service agreement is part of Public Service's interruptible gas transportation tariff. Generally, interruptible gas customer service can be stopped in order to maintain reliable service to firm customers. In exchange for this less reliable service, interruptible customers pay approximately 60% less than firm customers. At one of its facilities, Olson's receives gas service directly from a 3-inch pipeline that services only that facility, and that pipeline connects upstream to Public Service's NF19 system. Olson's service was not interrupted between 2014 and February 2021, but was interrupted 7 times in January and February of 2022, and 5 or 6 times in January and February of 2023. Olson's filed a complaint, which initiated this proceeding, asserting 4 claims. Claims 1 and 2 alleged inadequate facilities and violations of Colorado statutes 43-1012 and 44-101. Claim 3 alleged discriminatory treatment in violation of Colorado statutes. And the 4th claim sought a declaratory order clarifying that changes made to accommodate Olson's transitioning to a firm customer would be considered system improvements rather than line extensions. The recommended decision denied all 4 claims. For claims 1 and 2, which are the focus of Olson's exceptions, Olson's argued that interruptible customers are entitled to reasonably reliable service, and while obviously not firm service, and also adequate facilities. In the context of the interruptible nature of their service, the company does not provide it with reasonably reliable service, Olson argues. Olson's also asserted that the company's applicable service agreement and tariff do not meet the intent of Commission Rule 4203B because they do not establish specific terms and conditions for interruptions and curtailments of service as required by the rule. According to Olson's, neither states that typical cold weather events can cause an interruption or set forth temperatures at which interruptions will occur. The ALJ concluded that Olson's did not carry its burden of proving these claims. The ALJ found that Public Service's gas tariff makes clear several points: that residential customers receive the highest priority of service, interruptible customers are subject to the availability of capacity in the company's pipeline system, interruptible service can be interrupted for a variety of reasons, including lack of system capacity. The decision to interrupt service to such customers is solely up to Public Service, and that firm gas transportation service has priority over interruptible service. The ALJ was similarly unconvinced by Olson's argument that the gas and service agreement violate Rule 4203B, finding that public services gas tariff sufficiently specifies the terms and conditions for interruptions of service. In its exceptions, Olson asserts that the recommended decision applies the wrong standard of review because it reviewed whether the interruptions comply with the company's tariff and not whether the company's facilities and service are reasonable. Olson points to Colorado Revised Statute 43-1012, which provides that every public utility shall furnish, provide, and maintain such service, instrumentalities, equipment, and facilities as shall promote the safety, health, comfort, and convenience of its patrons, employees, and the public, and as shall in all respects be adequate, efficient, just, and reasonable. Olson's argues that it may properly challenge the sufficiency of the rules governing interruptions as set forth in the tariff, and that tariff compliance is not a defense if the rules and service are not reasonable. Rather, Olson's argues that the statutory requirement for adequate facilities and service is independent of the tariff contents and trumps the tariff. Olson's acknowledges that interruptible customers can be interrupted, but contends the question is whether the service and facilities provided to Olson's as an interruptible customer are reasonably reliable. While it may have been proper to interrupt Olson's service given the company's system as it exists, Olson argues that it is not proper for the current situation to continue indefinitely with continuing increases in interruptions at higher temperatures. Olson's assert that this trend indicates that the company's facilities are not adequate to support increasing number of firm customers and reasonable interruptions. Olson's argues that if the company's system has constraint that requires the deterioration of service faced by Olson's in normal weather due to system growth, that system is not adequate, and the Commission should order public service to rectify the system constraint. In its response, Public Service argues that the ALJ correctly laid out and applied Colorado law. Public Service argues the findings were properly based on Olson's failure to adduce substantial evidence in the record, and that the company did not violate any Colorado statute or any of the Commission rules or tariffs. The company contends that Olson's is asking the Commission to adopt a new standard that interruptible service must be quote-unquote reasonably reliable, while ignoring the contractual terms of the service agreement, which state that service will be delivered on an interruptible basis. Public Service further points out that neither statute Olson's relies upon requires that interruptible service be reasonably reliable. The company points out that both its gas and interruptible tariffs, which were in effect at times relevant to the complaint, have been approved as just and reasonable by the Commission in contested and litigated rate cases. Lastly, Public Service states that Olson has provided no credible evidence that its gas distribution facilities are inadequate. Rather, the company points to evidence provided by its witness who testified that Public Service was able to provide reliable service to Olson's facility 98.9% of the hours involved, and argues this fact demonstrates the sufficiency of the system's capacity to provide interruptible service. I can pause here for your discussion or proceed to offering your recommendation.
I'd like to hear a recommendation.
The Council recommends denying Olson's exceptions and affirming the recommended decision. In reviewing Olson's initial complaint, the ALJ found that Olson did not bear its burden of proving its claims by preponderance of the evidence. Rather, the ALJ found that the evidence in the record demonstrated that Public Service interrupted Olson's service in accordance with the service agreement and gas tariff. Under the agreement and tariff, Public Service can and did interrupt Olson's service to ensure safe and reliable service to firm transportation customers. The ALJ held that Olson's failed to produce evidence disputing that Public Service had a permissible reason under the tariff for interrupting that service. Olson's argues that Colorado law requires that service to interruptible customers must be reasonably reliable in the context of interruptible service. However, this argument seemingly ignores the agreements it has with Public Service, which allows the company to interrupt service in order to ensure safe and reliable service to firm customers. And Colorado Revised Statute 43-1012 does not differentiate between firm and interruptible customers. In the recommended decision, the ALJ found that agreeing with Olson's on this point would fundamentally change the terms of the deal it entered into with Public Service, as well as the terms of the interruptible service and the gas tariff that the Commission has determined as just and reasonable. Additionally, Olson's argument that Public Service Public services system is inadequate because it has been interrupted more often in recent years is unconvincing. As the ALJ found, interruptions of Olson service are not evidence of inadequate equipment, facilities, or service because the public service Olson service agreement does not include any service warranties other than that Olson service will not be interrupted as long as there is sufficient capacity to serve both Olson's and public services firm gas customers. In this case, the ALJ applied the appropriate standard of review, properly considered the evidence in the record, which necessarily included the service agreement and gas tariff, and reasonably denied Olson's claims. Accordingly, Council recommends denying Olson's exceptions and affirming the recommended decision.
Commissioner Plant,
I agree with the recommendation.
Commissioner Gilman.
Thanks. I agree with the recommendation as well, and but did just want to make the point. I mean, demand response programs of all flavors will be essential as we move to kind of a reasonably cost future on both systems. So while I certainly agree with the ALJ and think she did a great job here, I think it behooves the company to ensure that the communications and kind of there's a good understanding amongst customers so we can keep them in demand response programs moving forward. So just want to make that point. There's a lot of space in between there. And I think it would be ideal for the company to ensure that if there are communication processes that need to improve or other clarity for customers to ensure we can keep customers involved in demand response programs and not be surprising them. That would certainly be ideal as we move forward. But I agree with your recommendation.
I likewise agree with your recommendation and support the ALJ's decision and would deny the exceptions and, just share some of Commissioner Gilman's thinking that this area is going to be much more controversial as we confront weather extremes and, see larger loads trying to join the system on an accelerated basis while we're trying to, manage capital investment in the grid. So I think this area is going to be increasingly fraught. With that, Commissioner Plant, any, I think Mr. DeCento, that can be an ABC decision denying the exceptions. Commissioner Plant, any further thoughts on this or anything else before we adjourn?
No, appreciate it. Thanks.
Commissioner Gilman.
Nothing additional. Thanks.
Thanks to all. With that, we're adjourned.